Good morning, everybody, and welcome to the hearing today where we're considering submissions to the industrial section chapters of the proposed district plan. There are only three of us at the table today, and that Cliff Bolger, who was unwell yesterday, has not appeared and haven't been able to get in contact with him, so we assume that he is in bed at home looking after himself, and wish him well. So the outline that we have for today then is we have the three commissioners, Maria Bartlett at the far end, Glenys Dixon and myself, Keith Ovell. Our timetable provides for us to be asking questions of the Section 42A author, and then we will start hearing from the submitters. So I'll hand over to Victoria Woodbridge, who's the author of the Section 42A report, in terms of anything additional that you wish to raise, particularly in relation to the supplementary evidence that you circulated. Thank you, Victoria.
Mic on. I have assumed that you've taken the Section 42A report as read, and hopefully you've also had a chance to review the supplementary evidence, and that, I understand, has been placed on the website and pre-circulated, so I don't intend to read through it today. Probably one just minor correction to the Section 42A report that Commissioner Hovell pointed out yesterday correctly, is that I noted I was co-author of the report when in fact I was the sole author. Unfortunately that is an error, so just make that clear. So I'm happy to run through my supplementary evidence for you if you would like, but if you feel like you've read that and got to grips with it, I'm happy to move straight to questions.
Okay, we'll go straight to questions. Thank you. Just to correct another minor error that's in it, at your paragraph 41, you referred to the Alliance Group provisions being addressed at paragraphs 258 to 260. It's 261 to 263.
Thank you, apologies for that. It's a tricky job keeping track of paragraph numbering.
At your section 7.3, and I guess it's for the authors of reports going forward, there's a number of submissions that are coming up in every report, and we're not required to issue decisions on every individual submission lodged. And I think the way that we'll be looking at doing this as part of the final catch-up hearing is actually getting a printout for the ones that you've listed on page 21 there. Their submission points are virtually to every standard, every rule in the plan, and we'll probably be looking at bringing them together in some sort of coordinated way for that decision. So just to flag that for yourself and for other authors. Paragraph 94 is with regard to the Gore South Development Area. And in the third line it talks about the technical advice that was received. What was that technical advice, and is there a copy available, please?
Yes, so as part of preparing the chapter, we commissioned some advice from WSP in regards to the three waters and capacity for providing South Gore area with reticulated services. So those reports, I can certainly send you a copy. They are online on the hearing portal page under technical reports, but I'm happy to provide a copy to you for that.
So is that for the current hearing portal? So that's Sorry, the authors of that report are?
WSP. So if you just go to the main hearing portal page, there's a...
I suspect we've got a copy of
Yeah.
it, if it was supplied as part of that. I just wasn't sure what it was.
I believe there's two separate reports. One deals with stormwater and wastewater, and the other one deals with
Right.
potable water.
Right. The recommendation that you've got with regard to potable water, and we've previously had reports and discussion on the amount of water that should be provided on sites that are outside of the reticulated area. And I think you've adopted what I call a more sensible and simple approach of not specifying any volume of water, but just saying potable water is to be supplied.
Yes, so I worked with Ms Scoos on this, and I believe she's got the same standard which she will be recommending to be amended within her residential zone. So we aligned to ensure that what I was recommending here lined up with her recommendation through the residential zone.
Right, so how the question that flows from that then, excuse the pun, is how is water for firefighting supplied or provided for?
Yes, so again, we did, so as you may recall, FENS asked that we include reference to their code of practice, and I think we've discussed in Hearing Stream 2 that a simple requirement to comply with the code of practice is potentially a little bit unwieldy in the plan, because there's a lot of different information in the code of practice, and it's a little bit onerous for people to wade their way through it, and also for decision makers to try and work out which bits apply. So we did issue the invitation to FENS to put forward a more streamlined version of that, which hasn't been forthcoming. In the industrial zones particularly, I do know, I saw the statement from FENS, and their assertion was that the Building Act doesn't cover firefighting, but I understand that the council's bylaw, subdivision and land development bylaw, does have provision for firefighting standards for commercial buildings. So in the industrial zone, that would be a requirement. And my understanding is as well in the building code, there is a requirement for buildings of a certain size to have sprinkler systems. But I wouldn't be opposed to having some requirements for firefighting provision. It's just trying to understand what that appropriately looks like, and that's what we were hoping to get from FENS. I understand the standard is, say, 45,000 litres, but I believe there's also requirements about the type of couplings that you have on tanks and the position of buildings and of tanks relative to buildings, sorry. So that was the information we were hoping to gain from FENS to allow us to craft a slightly more streamlined standard rather than just a requirement to comply with the code and practice, but we haven't had that as yet.
Okay, and we'll come back to that as part of one of the other recommendations. And sorry, I turned the speaker on so that we could hear from people there, but it probably should be the other way around. I guess in terms of our recording, we don't need it on. I'll just turn it off.
Only when they're joining by video.
Sorry?
Only when they're joining by video.
Okay, all right.
So just,
yeah.
before you move off that discussion, if then, because it's obviously only an issue for FENS when you're talking about unreticulated sites.
Mm-hmm.
And so when I look at, so on your page 24 in paragraph 94 of your section 42A and that third element of the standards where council reticulated water supply is unavailable, could it be as simple as having a D that is provision for firefighting water supply?
Yep, yeah, you could have something just as simple as that, and it doesn't need to specify the exact details. So, yeah, I would think that would certainly be better than nothing, potentially.
which flows through, I guess, to the standard on servicing, which is on page 25, which is probably more complex than what it needs to be. And a couple of questions come from it. So one relates to if you haven't got potable water. Number two, if you haven't got reticulated wastewater, then 3 and 4 applies. So I guess my first question is that where available, you're required to connect to reticulated water. What happens if there's no capacity?
In the reticulated network?
Yes.
Well, then you would probably be required to, well, I guess you would either be required to upgrade to gain capacity to suit your development, or you would need to work with council to find an alternative, which would be on-site provision, in which case you'd probably trip this rule.
Right. So the thought occurred to me that a far simpler way of writing that rule is that for servicing, a connection for potable water shall be made to a reticulated water supply, or if not available, D, E and F then follow. So it's all sitting in the one part of the rule rather than split. And similarly, where connection to wastewater is required, it shall be connected, or if not available, provided on site. Does that sound far more simpler?
Yep, that's certainly, you could streamline it that way, that would be fine. So
going to my next yellow sticky. So the South Gore Industrial Zoning and Development Area on page 49, I'm curious to learn what the property ownership is like in that area, and you've provided us with a plan. If you can just take us through that, please.
Yes, certainly. Okay, so if we start at the corner of Racecourse Road and the State Highway, you see quite obviously there you've got the racetrack, and there's what is it, 2, 4, 6 titles, or 7, 8 actually. There's titles there that are owned by the Gore Racing Club. So that is, although they're different titles, it's effectively in one ownership, that large area of land. So that's owned and operated by the race club. And then if we move further south, we have Lot 1 DP 8038, and that's owned by Mr. and Mrs. Huck. And then further south of that, we've got Lot 2 DP 8038, and that is Mr. and Mrs. Identon. Apologies if I'm pronouncing that incorrectly. To the south then, we have Lot 3 DP 8038, and Lot 3 DP 6488, which are both, Lot 5 DP 8038. Those 3 parcels are owned and operated by Silver Fern Farms. As you can see, they've got their main processing facility on one of the titles, and I believe from site visits and talking with Silver Fern Farms that they graze stock on the other sites. And then just at the corner there of Sale Yard Road and the right-of-way leading to other properties, we've got a parcel that's owned by Mr. and Mrs. Newland. Okay,
so where are the submitters in that area? Which are the lots that have made submissions?
Yep, so Mr. and Mrs. Huck at Lot 1 DP 8038, they made submissions in opposition. I don't believe they are speaking today, but I have addressed their submission in my Section 42A report. Silver Fern Farms also made a submission. Their primary opposition was in relation to the indicative road that's shown on the development area plan going through. So those are the 2 parties within the development area who have made a submission. Donna Vincent lives just outside the development area, and she has also made a submission. Her property is, it's just to the west of the Lot 3 DP 8038. It's got a sort of funny zigzaggy sort of boundary there. There's a single large building that you'll see. And she has also made a submission in opposition. There are also some other submissions. Deborah and Gary Gibson, and apologies, I haven't, bear with me 1 second, I believe they are further over. Deborah and Gary Gibson. Theirs is the property with the right-of-way that just extends along the western boundary there with the development area. So they own the property next to Miss Vincent and the property that borders on to Mr. and Mrs. Hooks and Mr. and Mrs. Edenton's property.
I have some questions in relation to the access way across Silver Ferns Farms and different options that might come up, but I'll keep those until they're present.
Yep.
To save the need of repeating them, but you've set the scene there. Is there any other information that commissioners need rather than questions that we should leave till later?
No, that's why I sort of passed to my left, is actually most of what I wanted to talk about was probably what's going to come through from the submitters and then tease out. So, and that area being sort of top of the list of questions.
Now, there's a series of submissions as well from Environment Southland in relation to hazard management and zoning of land. And the response that we have in this and other reports is that the matter can be dealt with as part of the natural hazards chapter. Until we actually get to that chapter and can be satisfied that it's going to work, then we may need to come back to these series of submissions.
Yes.
The Alliance Group submission, you've recommended that and on page 53, that land be rezoned, and initially I think it was the light industrial area, and in your supplementary evidence then just the general industrial area. But I think the red dashed line you've got on page 53 stays the same in your supplementary evidence.
That's correct.
Does that follow legal boundaries?
Yes. Yes, it does. I can, I certainly can prepare a plan which shows that. I'm just putting it on my screen now. It does look, actually no, it doesn't quite follow legal boundaries. It does, so if you look at the portion here, the sort of skinny bottom portion, then that follows legal boundaries. Where it doesn't follow the legal boundary is where we've cut it off there.
Yeah.
So it's just a portion of the site, the overall site, which is proposed to be zoned general industrial. That's consistent with the submission from Alliance. And it's also, I didn't feel it was appropriate to zone the whole site industrial. Right. We didn't really want a pocket of industrial there. The zoning really just reflects that they've got an existing activity there.
Yeah. Right, we'll come back to it when we hear from Alliance, but there appears to be a small triangular sliver of rural lifestyle zone that is within the boundary of the property.
It is that is actually a separate parcel. Are you meaning just where it juts out here?
No, on the left-hand side, how can I describe it? Just below the red dashed line on the left-hand side.
Do you want me to bring my screen over? I have it.
Oh, no. Yeah, we'll deal with it when we come to Alliance. I just want to be satisfied that we've got a sensible boundary in place.
Actually, before we move, this could be a matter that we pick up when we hear from Environment Southland in understanding that we do need to sort some things out in the natural hazard chapter. One thing that I was wondering about though was the relationship between the Tonkin and Taylor report, where it identified that raising floor levels on the eastern edge of some of the land parcels would not be an available mitigation measure because of the anticipated depth of flooding, but that the zoned areas, you know, to the majority of the western part of those land parcels, those kind of measures would be viable. And so I was wondering to what extent at this, like within the zoning, there's how might we differentiate that, or is that something to be left for the natural hazard chapter? So this was my question was, you know, is this something that simply gets addressed in those provisions, or is there something that might be done in the zoning to indicate this is not a place within this area that that those options are available?
Yes, so one thing I think Environment Southland asked for from memory was having the flooding delineated on the outline development plan. So that could be a possibility that you use the outline development plan to indicate potentially that area along the highway where it may not be appropriate. And I think it would be good to understand what, in sort of tandem with that, I think it would be good to understand what might be appropriate in that area rather than a sort of no build. It may be, so I expect you've driven past the area and there's, you know, sort of bookmarking the development area. You've got to, excuse me, like farm equipment, sales activities, and they've got their tractors and farm equipment along the front. And it may be that that sort of use of the frontage there is appropriate. But I guess the reason I deferred that as well to that is just trying to get a little bit more understanding as to what might be appropriate there, so that rather than just have a sort of no build area, you could look at whether that could be used for a landscape buffer or a storage area, or what might work in there. Because I think it's possible that those highway areas may be developed, you know, first out of the area. So just trying to give people a little bit more understanding as to what they can do on their sites, I think would be useful.
And do you think that's something that we follow up with Environment Southland when we're speaking with them, and then come out the back of that and have a further conversation?
Yeah, we certainly could do that as well. I had also primed Tonkin and Taylor to come along, but yeah, the timing didn't quite work. But yeah, if there's further questions, we can put them to Tonkin and Taylor also, and address that through a right of reply.
Are we also expecting Tonkin and Taylor might be available for questioning during the natural hazards hearing?
Yes, I believe that will be the case. I'm not personally involved in that chapter directly, but my understanding is that they will be providing technical advice, and so they'll have quite a key role in that hearing.
At paragraph 256, you talk about the submission from P&J Talbot. To understand what they're talking about, have you got their address, please? It doesn't show up on their submission.
Oh, okay. Yes, just bear with me 1 second. So they are they're at the very end of Sale Yard Road. They're next to Donna Vincent's property.
Right.
Yeah, apologies, I should have mentioned that previously when we were running through submitters in that area. So that's 42 Sale Yard Road is their address.
Yes. So their concerns primarily over, I guess, their amenity of activities running 24/7.
Yes, they've raised a range of concerns through their submissions about amenity values and consultation with themselves and other adjoining landowners.
So how will the noise standards give them some protection over the nighttime hours?
So the noise standards are organised so that there are noise levels which can be generated to a maximum level internal to the general industrial site. So if you were effectively on one site in the general industrial zone generating some noise, another site in the general industrial zone, it would be permitted to receive a certain level of noise. However, a site outside the general industrial zone in the rural lifestyle zone must receive a lower level of noise. So it's then down to the activity within the general industrial zone to mitigate their activity so that the noise received by those adjoining zones is lower.
And you think that's sufficient to protect their amenity?
Well, noise is one part of amenity. The noise standards were developed in consultation with a noise expert, and that was the advice we received with regard to noise. We've got a range of other measures to address amenity as well, things like the light chapter, where there's requirements to direct lighting down. Through the outline development plan, we've also proposed the landscaping buffer. We've got increased setbacks for buildings to the rural lifestyle properties. So we've tried to put together a range of measures to contribute to mitigating the effects on the amenity of those adjoining landowners.
Thank you. And in relation to their submission, and it further comes out of paragraph 309, I've got and also a reference back to your paragraph 151. Just bear with me. No, the 151 reference is in the report from Hearing Stream 1. I'll approach it from a slightly different way. Using the Wellington Style Guide that you referred to, which was extremely useful, in policies enable your sign to permitted, provide for is anywhere between permitted and discretionary, and avoid is non-complying, which makes a lot of sense. There's provisions that somewhere in this report talk about enabling subdivision, but subdivision requires a resource consent. So any policies relating to subdivision, is it appropriate to use enable?
Is that a policy within the industrial zones or the development area?
It may be the development area, but it jumped out while I was reading this report and linking it back to Hearing Stream 1. So
I think it's Dev 1P1. We've put enable subdivision and development that provides for high quality design and in accordance with outline development plan.
So should it be provide for? Or are you using the policy to say it will be approved?
No, I think the intent of the policy was to require subdivision to be in accordance with the outline development plan. So I take your point that enable may not be the best word in that case, and provide for may be a better fit.
You, on paragraph 319, refer to case law. As per normal practice, can we have a copy of it, please?
Certainly. What was that paragraph?
The paragraph number 319.
319. Yes.
So if you can just follow that up,
Yep.
I'd be interested to see it. It didn't come up. Now, again, Talbot's in paragraph 330 is in relation to General Industrial Zone P4, where they said that they didn't fully understand the policy, and I agree with them. I didn't understand it either, and I just want to pull up my copy of it too, please. So if we've got GIZ P4, talks about avoid activities that may undermine the vitality and function of the mixed-use zone, town centre and local centres zone, or result in conflict or potential reverse sensitivity effects with existing or anticipated industrial activities. So what I guess number one, why have we got reference to these zones?
So what we're trying to avoid in the industrial zones is fine-grain retail activities. So, for example, it wouldn't be an appropriate place to have, just a straight retail outlet, because those activities are more appropriately located in the town centre or the local centres. So what we want to try and do is keep fine-grain retail in those centres so that they're, the vibrant commercial centres for the district. But if we allow that fine-grained retail in industrial zones, then it has the potential to detract from those zones. So that's the purpose of avoiding it. And the reason for avoiding it is because you're wanting to, avoid undermining the viability, vitality and function of those zones.
So if the intent is to avoid fine-grained retail, why doesn't the policy say so rather than give us an amorphous blob?
I guess it's just trying to explain what the outcome is, why you're avoiding it.
But would I pick up that, in fact, it's fine-grained retail that you're trying to avoid?
Yeah, I mean, I don't think, and I'd have to double check, but I don't think we have a definition of fine-grained retail. So, yeah, I guess if you had just a policy that said avoid fine-grained retail, it might be a little bit too specific to sort of capture what the intent is.
Are you also trying to avoid large stores going in that area?
Yes.
Destination type things?
Yes, yeah.
So
So there's fairly specific criteria for retail activity within the general industrial zone.
Right.
I guess the purpose of the general industrial zone is to keep, and the framework is such that it's to keep land for industrial purposes. So that's the primary use. So other activities have the potential to result in a loss of land for industrial activities, which is not a good outcome, or B, have the potential to detract from other centres, which should be the commercial hubs for the district.
Okay, because where my thinking comes from is that if there's a resource consent for a commercial activity in the industrial zone, what you're going to be arguing about is the viability and vitality of the commercial zones,
Yes.
not whether that activity should be in the industrial zone.
Well, I guess you've got policy P3 as well, which says avoid non-industrial activities from establishing unless, and then a range of criteria. So I guess you would read the policies together in that instance.
Any other feedback from others on that?
I think that's probably the key, is reading them together.
Okay.
It's helpful to have your thinking around P4. And I can see Commissioner Huvau's point in terms of where the conversation would be focused. But I can also see that when you apply those two together, you'll probably get closer to your answer.
Okay, over on page 75, deals with rules GIZ 6, 7 and 8. And there's, at your paragraph 3, 6, 8, again the Talbot one, there's no setbacks for stored items, only buildings and structures. And what's in standard S8 referred to in your paragraph 368 is that standard requires outdoor storage areas to be screened from any rural and residential zoned sites. Now, the submitter is on rural lifestyle land, and so that isn't referred to, and I'm wondering whether it mightn't be better to either make reference to rural lifestyle, now we know where they are, or sites used for residential purposes.
Yes, I mean, I think what we've done there potentially that makes it less clear is we've sort of lumped rural zones and residential zones. So the intention is that sort of any residential zone, as in general residential or medium density, large lot, and any rural, as in, you know, general rural or rural lifestyle, but appreciate that might not be wholly clear. So yes, an option to make it a little clearer might be to specifically reference the exact zones.
Although, so we're talking about standard 7 in the screening. I can see 1A has got rural lifestyle zones.
Yes, I think we were talking about S8. So 1B just says rural or residential, so it may be just that there's a bit of inconsistency between the drafting styles in those two different standards, so it may be more appropriate to adopt the format in S8 and refer specifically to the zones if you think that would assist.
Sorry, did you mean the other way around? Did you mean referencing standard 7
yes.
approach in S8?
Yes. Yeah. Sorry.
Yeah. Thank you.
That certainly was the intention of the rule, but I appreciate it might not be clear, so I can...
Okay, over to looking at standard 3 over on page 81, paragraph 401, talks about the HWR property opposing S3 and seeks the standards amended to require a minimum 2 metre setback where the boundary joins the site, because they think the 10 metre setback to the rural lifestyle zone is excessive. So I guess my question is, what is the purpose of the setback?
The 10 metre to the rural lifestyle or the 5 metre?
Well, both of them. What's it trying to protect, achieve, etc.?
It's trying to ensure that amenity on adjoining sites where there are more sensitive activities is, I guess, protected and managed. So in effect, internalising effects from the industrial activities within the industrial zone as much as possible. So the 10 metres to the rural lifestyle, that really came about as part of the development of the outline development plan and the feedback we received from adjoining landowners at the draft district plan stage. And so the 10 metre setback goes a little further than the 5 metres, just to try and offset, some of those concerns raised by those landowners. And I mean, if you look at the map you've got in front of you, some of the adjoining rural lifestyle properties where their dwellings are sited, it is relatively close to what will be the industrial zone in the development area. And so the setback just sort of reflects that existing situation. And I guess in the development area as well, that's also coupled by the fact that there's a requirement for a 5 metre landscape buffer there. So you would have the landscape buffer and then a further, 5 metres of setback.
So the landscape buffer, that probably comes, where's that referred to in the rules?
It's in the development area chapter.
Right.
So when you read the development area, you read it in conjunction with the underlying zoning as well. So if you have a look at Dev 1 S1, there's a landscaping standard there.
And that requires a landscape plan to be prepared. So that's S1, is it?
Yes, that's right. So that sets out the requirements that the buffers provided in the location it's shown on the outline development plan, which is along the boundary there with the rural lifestyle properties. Some requirements about the sort of height and of species there, and then the landscape plan is supposed to ensure that landscaping that gets put in is actually, going to be maintained and that it's appropriate to actually achieve the purpose.
So is it envisaged that the landscape plan requires approval in some form? The way that's written, it says the landscape plan shall be submitted. There is no process for considering its merit.
Yes, you could add the words provided and approved there.
And what guidance then do you expect in terms of the person who's approving it? And who would that be? Is it the chief executive or what? Or the council?
Well, I would have envisaged that it was just assessed as part of the PIM check at building consent stage. So, you would assess compliance with the rules. You would look at a landscape plan and determine that it meets those criteria that's set out in A to G.
Do you envisage one of us, for example, just submitting a plan saying this is what we want to do, or do you think it should come from someone who's suitably qualified?
I did think about that, but I didn't want to make it entirely onerous. I definitely don't think it needs to be a landscape architect. If it's got all the information, then I'm not sure it needs to necessarily be from a landscape professional. A draftsperson or a designer could include that information.
Okay, I just had a little bit of thoughts about item G as well, which says ongoing weed control maintenance program. If you're doing your landscaping correctly, after about 5 years, you shouldn't need any ongoing maintenance. So whether the word ongoing is needed is because it's required to be reviewed every 5 years, I think, somewhere.
I don't recall that.
May come up in one of the other chapters. I think it might be tomorrow.
Just thinking about that last exchange and your reasons for not thinking you don't want it to be too onerous, don't need a suitably qualified person necessarily, and that the landscape plan is going to be provided with any building consent or resource consent, so it becomes part of the mix of those considerations. Should we be identifying the purpose? Because I think your answer is related to the purpose of the landscape plan. And so things like, it's really the density of screening. You're not trying to achieve, for instance, ecological outcomes necessarily, but you're definitely looking for those appropriate screening effects, and they're presumably going to assist maybe noise attenuation, that kind of thing, visual and sound. And do we need to be identifying their purpose?
Yeah, good point.
Yeah, that is a good point. You could reframe the standards slightly to have, a purpose at the top, and then, so you have the standard where it's, I guess it could be one, so a landscape buffer is providing the location, and then you could have, the reasons what the purpose as part of one, and then the other sort of 2 and 3 as a, and so it shall. So the purpose being, I think it's more really about visual amenity. My understanding is landscaping doesn't really provide much in the way of noise attenuation. So I think it's more visual and sort of general amenity outcomes. So yes, I think you could probably use 1 to outline that purpose, and then instead of having 2 and 3, you could have them as sort of maybe subsets of 1, as it were.
I think it would help understand for somebody, say, processing the resource consent and looking at those matters A to G, what they're considering when they're thinking about each of them.
Yes, I can see that would make sense.
In paragraph 430, you talk about S9, and I think the purpose of S9 is to enable runoff stormwater to soak into the ground.
Sorry, that's the permeable. Yes, yep. So you don't get, house sites. We've got a definition of landscape permeable area, and then if you look at the matters of discretion, it's, I guess it's partly about stormwater, but also it will help with visual amenity on the site as well.
Okay, so if it is partly about stormwater, what the submitter is really raising is things I've seen in places like Vancouver, where the way they design their car parks is with permeable surfaces that actually allows, rather than having water run off on the car parks, it actually just drains away in situ. And so the way I picked up their submission was that they want the ability to use the technology in car parking areas to provide for some of that permeable area. What's your view on that?
Just going to check the definition of landscape permeable area to see what it covers. So the definition of landscape permeable area means any part of a site which is grassed or planted in trees or shrubs and is capable of absorbing water. So I don't think in that case you would be able to say that a car park achieved that standard because it wouldn't meet that definition. So I suppose it then comes down to what's the primary focus of the rule. If it's primarily about stormwater runoff, then yes, you could use car parking techniques, the finish or other sort of non-sealed areas to achieve that stormwater drainage. But if it's trying to provide also a means of mitigating visual amenity effects, then that wouldn't necessarily achieve that outcome.
But you've indicated that the purpose of the boundary planting is to provide for that screening and minimising.
So that's in the outline development. The development area has got
Right.
that buffer. This standard applies to any industrial site, so sites that are outside the. I guess it also provides a sort of limit on building coverage and what have you as well. So
I do recall there is a percentage of the site that needs to be permeable.
yes, I think this is a rule that we've got across other zones as well from memory. Where there other zones where there may be higher sort of density of development. So yeah, just looking at the matters of discretion, it does, it does talk about visual amenity as well. So I think the intention is to provide some relief from hard standings and built form as well as stormwater.
Yeah, S6 relates to all industrial areas, doesn't it? And that requires an average width of 2 metres of landscaping along the frontage.
Yes, that's correct. So you could use so you've got your 2 metres along the frontage, so that could count towards your 10%.
What policy deals with, is relevant for that standard?
So that would be P5. So we've got, if you look at point 2, we've got outdoor storage and service areas. Is that P2? Oh no, sorry, 4. Providing landscaping, particularly along road frontages and boundaries of sites in the residential and rural zones to maintain amenity values within the zone and in streetscapes.
And there's no submissions to that, is there?
Not as far as I'm
No.
aware.
All right. Now, the other thing that I picked up on that makes sensible reading, yourself in the report for tomorrow refers to the State Highway Network on page 93, paragraph 480. Elsewhere in the plan, it's referred to as an interregional connector, which seems a mouthful. I guess the consequence of the wording you've got here is that we should be using State Highway Network as an easily understood term throughout the plan rather than interregional connector, whatever it was.
Yeah, I agree. A state highway network, it's pretty much,
Yeah.
as it says. I mean, that might be something just to raise at the transport chapter hearing as to how that different terminology is used.
Okay, over on your page 95, you're into a discussion about the upgrades to intersections and recommending at your paragraph 492 that the financial contribution approach be followed by council. Now, the long-term plan is going to come out before decisions are released on the district plan. What happens if the long-term plan does not include a development contribution policy? What would you then be recommending us do?
And that's why I've sort of talked about both development contribution and financial contributions, because your financial contribution policies don't link so directly to the development contribution. So, as you're probably aware, development contribution can really only be captured where it's got a schedule of, works, and that work schedule generally comes from the long-term plan. So if council is not identifying any upgrades through their long-term plan, then you wouldn't really be able to take a development contribution on that. So a financial contribution works slightly differently in that you don't have to have a list of projects to be funded. You could ring fence a financial contribution to the area. There's a variety of ways to do it, but that's why I've sort of sat on the fence a bit, and yeah, because I don't know what's coming out in the long-term plan. It's a tricky, I understand where NZTA are coming from with their submission, and I don't necessarily disagree that, yeah, the issue is how it would work in an equitable and reasonable manner. Is that my concern would be if you hit a trigger point, then the first 10 developments could sail through without having to do something, and poor unlucky number 11 gets hammered with the lot, which I don't think is an equitable outcome, really. But there's not an easy way to write it in a plan that requires you either do the upgrade first, in which case council has to pay for it and then claw it back, or you gather the funds, I believe, and then do the upgrade. So I understand what NZTA's concern is. I'm just, it's a difficult thing to build into a district plan. And those were the only kind of mechanisms that I could reasonably see as addressing that.
Given that we're going to be privy in terms of what is in the long-term plan, if it becomes apparent that drafts are suggesting there won't be a development contribution policy, then what you're indicating is that there probably needs to be something in the district plan.
That would be an alternative way of dealing with it, yes. I mean, you could have a financial contribution which is just for this area, or you could have a financial contribution that helps with other areas if you're not going down a development contribution path. But that's a sort of separate piece of work that needs a bit more thought and analysis, and I know there has already been some, a fair bit of discussion around those two approaches previously, sort of outside of the district plan hearing process.
And that would require a variation or plan change?
Yes, and I would say it would probably be a plan change, because I think you'd struggle to get that amount of work done in time for it to be a variation. There is a fair bit of work involved in putting together a financial contribution. It's not entirely dissimilar to a development contribution provision in terms of the amount of work that's needed.
Over on your page 106, there is a recommendation at paragraph 548, and the next page has fallen off my report. Where do I find that provision?
Oh, that's so that's in the subdivision chapter. I did just put up appendices with the changes to the subdivision chapter. So that is sub R9. So what we did was we addressed, there's a subdivision rule and a subdivision standard that relate specifically to the Gore South development area, and so we addressed them as part of this hearing as opposed to within the general subdivision chapter.
Okay, so by including the word including, does that mean that the airports, railway lines and state highways must be adjacent?
Yes.
Because the reverse sensitivity could be on the other side of the state highway or not an immediately adjacent property. So you've actually narrowed the rule from including the airport to only including it if it's adjacent. Is that your intention?
Yes, because I think if the airport's a kilometre away, you don't need to really be worrying about reverse sensitivity. It's too far. So the intention is adjacent land.
But when I look at the submissions that have come in from NZTA, their concerns about the impact of road intersections on the highway, which aren't necessarily adjacent to the property being subdivided.
Yes, I see what you're saying. So sorry, I'm just sensitivity on adjacent land uses. So I suppose it. Oh, sorry.
I'm just, you're looking at R6. I think you said R9 before.
Oh,
I'm just
sorry.
piping up.
R6, thank you. Yeah, I suppose I mean, for the state highway, the reverse sensitivity issues tend to be centred on noise. But I do accept that it may not just be sites that are adjacent. So yeah, maybe that including does narrow that scope, and so potentially not appropriate.
Okay, I've got one other one. It's on the back page of your supplementary evidence, but I'm not too sure if it was the supplementary or the updated plan provisions. I can easily come back to that. So that's really all from me at this stage. Any other questions from the front table?
Yeah, no, I think that's a good beginning. And again, I'm mostly interested in, I'm trying to work out if I ask some of my questions around the ODA now or just wait. Probably one aspect of the development area that, as I was going through, I'd picked up, I'll just see which paragraph it is before I go on. So at para 22, so I'll just find it, make sure I'm in the right place.
Is this supplementary?
Para 22 of your supplementary. And so as I was following through, I can see on the ODA that there's this intention to stage 1, 2, 3.
I think there's not an intention to require staging.
That's what I wanted
Okay.
to talk to you about, because it seemed to me that there's a link between some of the dialogue that's going to go on around the roading.
Mm-hmm.
To me, seems to have quite a close link to this idea of staging.
Yes.
And what may or may not be available at the time of some future stage, or potential development of, say, the hook land.
Mm-hmm.
And so then it seemed to me that staging might be part of the solution, if what you're trying to solve is those bits of land that might otherwise shoot out to the state highway. And that if, for instance, the stage 3 area, which looked to me to be prime for setting up an access off the state highway and onto like the racecourse road or the raceway lane, that made a lot more sense than trying to shoot a road out in a future development area where you've got resistance from those submitters. So to me, that was kind of at the core of it, that thinking about the roading issue that had come up, but it seemed very much to me to be related to staging. And if there was no control actually intended around staging, is that part of the problem definition and solution?
Possibly, yes. So we did, and I can ask Lindsay if she can print out sometimes. We did do a bit of work around staging, and there is some background plans that I can make available that sort of informed where we landed with the roading. So we just, that the feeling was, rather than, how to frame the staging so that if somebody in a future stage did want to build before one of the other stages, we weren't necessarily constraining that. So what we don't know is how it's going to develop. We've talked to the race course, and we met with the race course, and we understand from them generally what they're looking for, and they have indicated they'd like to keep their racetrack for as long as possible, which is why the sort of initial stages of development are likely to be on the areas of land of the race course that are currently sort of undeveloped. But what is sort of less clear is what might happen in that future stage. And so I guess it was a sort of desire to ensure that if, say, Mr. and Mrs. Hook, I know they are opposed now, but they could sell their site and somebody might buy it and if they did want to develop ahead of some of those others, it didn't want the plan to sort of constrain that. But yeah, that is something you could look at. I think if you could build some flexibility in with that staging, then that is an option for that.
So if you want to hold on to the flexibility of staging, and that the race course is sitting smack bang in stage 3, in, as you say, they're not going to be looking to progress that early. But just when I look at this picture, if the Hooks, or somebody other than the Hooks who purchased that land, wanted to advance, whatever way you look, they're going to have to work with adjacent landowners for creating any access way. And I don't honestly understand why we aren't talking about access that heads up towards Raceway Lane and makes some use of the skinny lots, or or some of this land up here that's owned by the racing club and not part of the racetrack.
Yeah, we did look at that as an option, and we did a site visit and we looked up there, and trying to recall why we moved away from that. We did move away from that, I think in part to avoid having a road with heavy vehicles sort of going right adjacent to those rural lifestyle properties. That is an option, and it probably would be helpful if I had, so Ruth Allen from our urban regeneration team, she was quite closely involved with this, and she came on the site visit, and certainly her and the urban designer provided some advice on options for those roading links. So that was something we did certainly look at, and we walked that whole site and had a look at that. But then ultimately we sort of moved away from that in terms of an outcome, and we did also have some input from traffic engineer as well, and there's a technical report on the website about that, and looking at that intersection as well onto Racecourse Road.
So is this mostly around the character of Raceway Lane then?
Yeah, so Raceway Lane at present is very narrow, so it would require quite significant upgradings to bring it up to a standard that would be suitable for heavy vehicles, and that intersection onto Racecourse Road. So at the moment, sort of when we went out there, Raceway Lane does provide a bit of an additional buffer to those rural lifestyle properties.
Just to let you know where my head's at when I look at this, those skinny lots 1 into 3861 look like helpfully road width lots that would have a buffer, as you say. Raceway Lane would then be in between there and those rural lifestyle properties, so that they would have some you know, and so you might then be looking at some sort of new access way onto Racecourse Road and managing that, which seems to me where you've already been having conversations with the racing club. They're fully part of this dialogue and this picture, and what we're hearing loud and clear from the landowners in the future development area is that they haven't been included in those dialogues and they don't share. They seem to be largely opposed.
Yes.
So you've got a willing landowner that you're in dialogue with, and that would seem to have the land that would enable this to occur. And if the only thing that's meant that you've moved away from that approach is traffic management, I would have thought we could just, or that intersection onto Racecourse Road, that to me sounds like a much more manageable proposition than what we've got in the ODA running through a lot of opposition.
Yes, I have to go back and re-look at why we moved away from that, because I know we certainly did look at that as an option, but I'm not sure. Are you saying then that you wouldn't need the connector road through, the indicative road through, say, the Hooks property and the Silver Fern Farms? Because
So what I'm imagining is this, that see those Silver Fern Farms sites,
Mm-hmm.
either have that existing right-of-way access point, or they have access onto Sale Yard Road. Newlands have both the right-of-way and the Sale Yard Road. And then you've just got Hook and Odenton who need a way to either get onto Sale Yard Road or the Racecourse Road. And I thought, so those two land parcels seem to be the ones that we're trying to solve, those Odenton and Hook land parcels, and there would seem to be an alternative path for them, which might be to utilise the racing club land to get up and away, rather than the proposed cut through to Sale Yard Road through Silver Fern Farms land.
Yes, so yes, I think so. One thing we did want to have was a through connector right through the site, and that's where we landed with that. And I guess the point I was making in my supplementary evidence to Silver Fern Farms is this is just an indicative. There's nobody's going to come along and build the road on your land unless you develop. That's part of the development. I'm not sure about using the right of way to the north of those properties. It's a privately owned right of way by somebody who's opposed to the development area. It's currently outside of the development area boundaries. It's quite a narrow, and again, it doesn't, even less so than Raceway Lane, it would mean that it, that the heavy traffic is right by those properties. But yes, there might, I guess you could, the Silver Fern Farms are the only one who've opposed outline the road on their property. So I guess it depends what you're trying to achieve. If you're trying to address their submission by redesigning the road to go up across the top of the racecourse down Raceway Lane, then I suppose, you'd have traffic coming across the Hook and the Addendum properties onto that. Taking all the traffic that way, I guess, increases traffic effects on that Racecourse Road junction with the State Highway.
So just to let you know again, what I'm imagining is that because some of those properties already have direct abutment to Sale Yard Road, you're really only trying to cater for, and just correct me if I'm wrong here, but you're really only trying to cater for those, the locked-in parcels of Identon and Hook.
Yes and no. So yes, you are, but it's also about splitting the traffic between the two intersections as well. So, excuse me, if you've got traffic coming up from the south there, rather than go up to Racecourse Road and then back through, they've got the option of going up Sale Yard and through that way. So I guess you're sort of splitting that trip generation between the two intersections with the state highway, rather than having everybody rely on the one intersection.
So, yeah, I followed that. So I was thinking that you would end up with split traffic, because those sites in the future development area, so aside from Hook and Identon, those ones would be heading towards Sale Yard Road. So it's only the traffic that's generated from the Hook and Identon lands that you'd be also heading up towards Racecourse Road. And I guess my point is if the roading is indicative, which is what you're saying, and we know that we've got a landowner that is not supportive, and it would be dependent on their support for that to occur, what is the value of that indicative outline? I would have thought it would make a lot more sense that your indicative outline has more of a shot. And I just thought potentially you'd have more of a shot with the landowner that you have been in dialogue with, that does seem to be at least open to being part of the staging.
Understand.
Can we continue this when Silver Fern Farms is here? Because I think it does impact on what we're going to hear from them as well.
Yeah, I just wanted to do as much as possible to set up the conversation.
Yeah, no, that's fair. And I understand what you're saying and where you're coming from. And I guess, as you said, it is just indicative. So if somebody had a better solution, the setup, it does provide for that. But yeah, I'd have to go back and look back through our notes and back through the other information as to why we moved away from that roading suggestion that you've put forward, because I know we definitely did consider that as an option.
And can we consider that? Can you have a look, so maybe we can have a further talk about it after lunch, and maybe even bring one of the others up online?
I can see if Ruth is available for that.
Because we'll be having a break very shortly before the 11 o'clock, people zooming in.
Yep.
My final question was in relation to paragraph 72 of your supplementary, where you talk about an objective, Ngāi Tahu cultural values as identified in MW 2.3, and the objectives and policies of this zone in the SASM chapter. I'm not aware whether, I doubt it's appropriate to actually have an objective that says you must comply with policies, because an objective is the endpoint that you want to reach. So I'd just like to flag, I'd like you to give a little bit more thought to what that reads. And I know it's come from a different report, but I'm interested in your feedback on it, and I'll come back to it later in the day.
Yep, sure.
Okay. So
then I only had one more thing, and that was in your supplementary, well, not just in your supplementary, but you're referring to the Kaitiaki plan in the MOU when thinking about the Mataura site alliance and the setbacks. I just wondered, does the panel have access to the Kaitiaki plan or the MOU that you've been able to draw from?
I haven't shared it with the panel. That's probably a question for Mr. Richardson when he comes up, as to whether it's able to be shared, beyond this. So those, my understanding of Mr. Richards can probably expand on this, but they were a requirement of a wastewater discharge permit that was issued by Environment Southland, and there was conditions attached to that consent which required those, the preparation of those documents. But yes, certainly I think hopefully Mr. Richardson can expand on that a bit more and answer that question.
And when we've got both submitters here, we'll need to have a chat about site visits.
And probably the last thing there on that setback issue was just thinking again about the purpose of the setbacks being
Yeah.
a guide to resolving the matter.
Yeah, let's talk about that with the submitter here. Right, I propose to have a 5-minute break before we've got people coming online at 11 o'clock. So we'll adjourn until 11 o'clock. Thank you.